Hey, folks, welcome to Ask a Lawyer Live Wednesday edition. Today, we're going to be talking about an employment law topic, and I'll get into that in a second. Before we go there, though, I just want to remind people that during the presentation, you can put your questions in the chat, either in Facebook or YouTube, wherever you're watching. If they're related to the presentation, I'll ask them. I'll answer them during the presentation, but we're going to have a live Q&A after the presentation so that basically you can ask me any type of question on disability employment law issues. Today, we're going to be talking about constructive dismissal and what it is and this type of thing. Now, tomorrow is our call-in show. We successfully, with a little bit of hiccups, did the call-in show last week. So if you're watching and you would like to call in and be able to speak to me directly, it's a phone call, so you won't be appearing on the screen. We'll just hear your voice. Hopefully we won't have the technical issues again this week, but I can't make any promises. We're still kind of new at this, but it did work last week. Friday, as of right now, I do not have a guest book for Friday, so I'm either going to take Friday off or maybe I'll just come on and just do a kind of freewheeling talk and pick a topic to cover. So we'll see. Keep your eye open. If I'm going to go ahead with it, you'll see it scheduled on the YouTube channel. Okay, so let's dive in here. Let me get my mic ready. Let's dive in. So we're going to talk about constructive dismissal, and I do have some slides as always. So I'm going to redo the opening because I do clip this part of the presentation out of this live stream and use it elsewhere. So I'm going to start with a new opening and just bear with me. All right, here we go. Hi, welcome to Ask a Lawyer Live. I'm David Brannen, employment lawyer here at Resolute Employment and Disability Lawyers. Today, we're diving into the topic of constructive dismissal, what it is, how it works, what things you need to be thinking about if you're facing it. This is one of the most misunderstood areas of employment law, and if you're not careful, you can really make a mess of things and lose out on your rights. So let's dive in and see what this is all about. Okay, first of all, let's talk about what is constructive dismissal, just so we're all on the same page. This is something that happens when your employer doesn't actually fire you, but makes major changes to your job such that it violates your employment contract with the employer. The law treats it just as if you have been wrongfully dismissed, even though you technically have to resign with a constructive dismissal. So with the constructive dismissal, you have to resign and cite the reason is that you've been constructively dismissed by one of the reasons that we'll talk about here. So for example, if your hours at work are drastically cut or your role has changed, that might qualify as a constructive dismissal. The key thing, though, is that it has to be a fundamental change, and there can be some gray area around what that means, but it has to be a fundamental change done without your consent. Now, let's look at some examples here. So a major pay cut or demotion is one of the most common reasons for a constructive dismissal. This can happen out of the blue, or sometimes if you're coming back off a sick leave, this type of thing can happen. But if there's been a major change in your pay or a demotion in your responsibilities, that you've been moved to from a certain level of management to non-management, or anywhere you've lost seniority or status within the organization, that can constitute a constructive dismissal. Not always. Now, if you're faced, sometimes it can be related to travel. So if you're suddenly forced to move to a different city, then depending on the distances involved, that may be a constructive dismissal, but not always. And there is an area that's kind of growing in importance, and that would be like toxic workplaces where the employer is refusing to address a toxic workplace issue after you've given the employer reasonable time to address it. You do have an option, if the facts are correct in your case, that you could resign and claim a constructive dismissal. All right, but remember, not everything is going to qualify. There has to be a substantial change in the core parts of your job, or the workplace has become intolerable. So let's look at some common traps and misconceptions. This is where people can get tripped up when it comes to constructive dismissal. The biggest mistake is quitting too quickly without legal advice. It may not, if you just do some research online and see, okay, there's this, there's that, I have a drop in pay. I think it is a situation where there's been a major change and you quit. There is a chance you've gotten it wrong. So if you quit without it actually meeting the legal test for constructive dismissal, then you've quit and you'll have no recourse. Unless it's very hard to undo that if the employer has accepted your resignation. So that is not the way to go about it. You want to go about it by documenting things and having a paper trail that you can prove of the type of things that we're talking about. So if you're going to get a demotion, you'd want to have it in writing or somewhere where you could prove that they actually said it. Because you could quit and they'll say, no, we were never going to demote them. There's no evidence of that. And if it was only told to you verbally, you didn't make notes of it at the time or confirmed it in an email back to them or something like that, then you will have problems. Now, unfair treatment, a lot of people will think there's a very fine line between unfair treatment, harassment, and toxic workplace. Harassment and toxic workplace have to be extreme, and there's a whole level of like unfair treatment or unwelcome treatment that does not meet that level and would not be enough to constitute like a toxic workplace that you'd be able to leave. So you really have to get legal advice on this and get an outsider's view on whether the type of bad behavior or things that are going on, would it be enough to allow you to claim constructive dismissal? It might not be. It might just be that you have to report it and give the employer opportunity to deal with it beforehand. Now, sometimes employers will try to pressure you into quitting so that they don't have to pay severance. So be careful about that. Get legal advice before you quit. If the employer is doing things to kind of pressure you into quitting, you may not want to quit. Or if you do, you want to be able to quit in a way that you can claim a constructive dismissal. And again, it's very fact driven on a case by case. So this is why it's important to get legal advice. Even lawyers giving this type of advice are very worried about it because no one wants to get it wrong, right? You don't want to get it wrong because now you've resigned and you would have no right to severance pay. So signs that you may have been constructively dismissed. So these are things to look for. Again, I'd still get legal advice, but if these types of things happen, then you know that we could be looking at a constructive dismissal. Now, the key one would be given some type of ultimatum, accept this or leave. We have many cases that go that way. You're given sometimes you're given a new contract and you say, you'll sign this new contract or you're done. And then you're not really getting anything new for the new contract. In some cases, the new contract is worse. You're worse off. That type of thing can be a constructive dismissal in some situations. Or like if your duties have changed dramatically without your input, if you've been suddenly put on a performance plan where there's never been issues or another warning. So all these types of things could be signs that you may be able to claim constructive dismissal. But again, it's very smart to run it by a lawyer before quitting your job. All right. Now, things you should do before you resign. Again, I'm kind of beating a dead horse here, but definitely get legal advice. You don't want to quit without having a plan in place. What a lawyer can do is help assess whether you actually have a strong case to prove constructive dismissal. Again, you have to be able to prove it. So a lawyer will know the kind of proof that is necessary. It can't just be verbal, your word. There has to be something written or documents that can support what you're saying. All right. The other thing too is sometimes if there's major changes, it is good for you to respond in writing, saying that you object to the changes and you would like things to stay the way they are and have them reject your input. That is quite important in many cases for a constructive dismissal. Sometimes employers will try to weasel out of it afterwards and saying, oh, well, we just proposed it. It wasn't necessarily going to go ahead, but they ended up resigning before we could work out. It was just a negotiation. And so you don't want to have that happen to you. You want to give them a chance for you to respond, give them a chance to say back to you, nope, take it or leave it type of thing. It's important to have them nail it down that this was going to be a definite change, not just something proposed or a possibility. All right. And if there's internal complaints processes, not every employer has that, but if they do have it, you could put a complaint in about how things are going with this changes to your job, you don't agree to them. It just creates a paper trail that is very helpful if you do end up resigning your employment. Okay, so timing really matters with constructive dismissal. So I've said that you don't want to just quit right away, but on the same hand, you can't wait forever. There's this idea that if there has been a change that have been brought in by the employer and you don't act on it within a reasonable time, that you've accepted the new conditions or condoned them. So this is something you need to be very careful about. If you are facing a possible constructive dismissal situation, you have a window of time, and I don't even want to give a range because it's different depending on the facts, but it would at least be a couple of weeks, a week or two, to maybe a month or more, but it'll be very fact driven how much time is reasonable for you to take to make a decision. And the thing is, you have to make the decision to do a constructive dismissal within a reasonable time. You can't come to a lawyer and say, well, last year they did this thing. Last year is going to probably be if a year ago, let's say, because last year might just be a week away, but a year ago this happened. That's probably going to be too long. But again, I would still want to see the facts because these cases are very fact driven on what's a reasonable time. All right. So don't sit on your rights. Get legal advice quickly. And if you are going to make a decision to resign and claim constructive dismissal, that has to be done promptly once you've got all the other ducks in a row. And the other ducks in a row would be maybe voicing your concerns, exploring other alternatives. Like, you're able to delay the time if those types of things are happening. But once you get a final, like from the employer, nope, take it or leave it, that is when you want to make a move. So with constructive dismissal, like, what does it cover? It's really no different than being terminated from employment. It's the same thing. So what you're entitled to is, if you've been constructively dismissed, what has happened is the employer it's treated like they fired you without giving you notice. So you are entitled to reasonable notice damages under the employment standard statute of your province, and possibly more if you do not have any limits in your employment contract that limits you to, say, what's allowed under the statutes. The statutes are lower. They establish the baseline, the bare minimum that employers must pay. And some employment contracts will limit your compensation to that. That is allowed to happen. If they don't limit it to that, then the law says you have a right to common law termination pay, which is a lot more than what you can get as the bare minimums. So that would be the next thing to figure out. Are you entitled to common law compensation, or are you limited to just the statutory amounts? Other things you can get are lost benefits during the reasonable notice period. So like your medical plan, paying into pensions. There's other things as well. If bonuses were coming up due, there's many things that can go into calculating what you would be owed, but it's mostly going to be termination pay, other benefits that you would have during the notice period. And in some cases, depending on if there's real bad behavior by the employer, then you can get things like aggravated damages, and in extreme cases, things like punitive damages. But those are going to be less common. On the other hand, if this involves like a discrimination aspect or element, then there's also human rights damages for basically for violating your human rights. There is kind of compensation for that is separate and apart from being compensated for losing income because you've been terminated. So in a nutshell, like, you can bring a case for discrimination depending on what province you're in, there's different ways to do that. Or you can bring a case for wrongful dismissal, or both, depending on the situation. So just in summary, how to move forward. Don't rush or quit. Pause and plan is the best strategy here. Explore your legal options. Get all your ducks in a row before pulling the trigger to make a decision to do a constructive dismissal. You can do the constructive dismissal yourself. Sometimes I've done it on behalf of clients. So the employer will find out because I'm writing on your behalf saying that you are accept this letter as my client's constructive dismissal. That can happen as well. So it just depends on the right way to do it in your case. But again, talking with a lawyer before you do it will help you gather the kind of evidence you need before you resign in order to support your claim. Now, if you need help, you can always get a consultation here at Resolute Legal. You can contact us through, there's a link below to go to the website. You can use our chat feature or phone in, and or just show up, or you could come on, you'd have to be you'd have to be confidential how you do it, but you could come on or ask a lawyer live tomorrow and ask questions back and forth. We also have paid, if you need a more in-depth consultation, we do have paid consultations as well that go beyond. A free consultation is it can't go into a lot of detail in legal advice, but we do have paid consultations that can go deeper. And people also can hire us directly to handle these types of cases. We do the cases on a contingency fee sometimes, which means you only pay us if we win, or some type of a fixed fee that is paid regardless of the outcome. All right, that's all for now. Thanks for tuning in, and we'll see you next time. All right, there we go. The clip is done. Thank you for bearing with me on that. So let's see here. I'm going to go here. Just going to grab a little drink. Let's get rid of that. There. Well, yesterday, I don't know if any of you people were here yesterday, but I talked for an hour straight. It was the longest thing I've ever done, talking about questionnaires. I call it the questionnaire trap. So questionnaires and video surveillance by insurance companies. How they use the two is kind of a 1-2 punch to cut off your benefits. Okay, we'll give it a second for questions. Might not be a lot of questions today. I can always do a shorter show today because of how long yesterday went. And again, it can be we can ask about constructive dismissal or any other question that you might have if there's anything you're interested in. There's a few things I'm working on that it's possible on Friday I may cover it if I can get enough of the research done, but I'm still trying to determine what are the kinds of income that are going to be included or excluded from calculating your entitlement for the Canada Disability Benefit. So if I can get that put together for Friday, then that will probably be the Friday show. But if I'm not able to, then probably we'll take Friday off. And we have a big project going on where we're launching a new website, and it is a nightmare from my point of view. Not because it's not going well and we're working with a good website developer, but it's just so much work. It is so much work. It's been the last 2 weekends I've worked around the clock from like sun up till sundown, working on that website, just doing the content, getting the pages ready. So I'll be quite happy to have that website thing over with, to be quite frank with you. All right. Looks like we don't have questions today, which is totally fine. It's totally fine. We will, what I'll do is we'll be back here tomorrow for Ask a Lawyer Live, where I'll be doing questions like this. And also we'll be taking questions from call-ins, people calling in. We had a brave soul call in last week and test the system. It failed, and then we got it working. So let's hope that I'll be able to get it working again this week. I thank you all for showing up. We'll see you back here tomorrow. Take care.